Member.
Thank you. Fair enough. Just wondering then if I could just ask the Minister of the Attorney General here some perspectives perhaps on solitary confinement and the use of solitary confinement in the correction system as a way. It's both used as both an administrative and in sort of a punishment perspective, and just wondering if the Minister has any thoughts on the use of solitary confinement in our correction system.
Attorney General.
Thank you. So I'm informed by my team that this current issue is a subject of ongoing litigation with the government, so I can't comment on it here. But I would ask the member to, I'm sure he has, reach out to PSSG about their confinement policy and how it works and what it's used for.
Member.
Totally intend on doing that. So that estimates is coming up at some other time, but just wanted to open very briefly with this and respect the Minister's response. Another issue that I've been canvassing this government on over the last while, I don't know exactly the time frame, is around the use of injunctions in our court system, and we've had a brief conversation about this, and I've asked about this question in question period, and specifically the use of the community industry response group police unit, that is RCMP unit, I should say. In the responses that I get from the Minister responsible for public safety, the Solicitor General, often talking about referencing the rule of law. And from the Minister, from the Attorney General's perspective, just wondering where the corporate interests and inherent Indigenous rights, the conflict that exists in how injunctions are sought and granted in this province have largely fallen on the side of corporate, the public convenience and the balance of convenience, and I'll say irreparable harm, usually falls on corporate interests, the right to make a profit, the right not to lose that ability to make a profit, and public perception of that corporation are often weighed very heavily in by our court system. And just wondering if the Attorney General would be willing to provide some comments on how that balance is being seen.
Attorney General.
Okay. I want to start by thanking the member for raising this important issue. And I know you've raised it, or the member has raised it in previous estimates, and it's allowed our team to really look into how these cases are determined in court and what that balance is. So just like generally speaking, we've looked at this idea of, so there's two types of injunctions with court. There's the statutory one. In that case, if there's, the courts will see if there's a breach in the statute that the public interest is automatically implicated. So I think really the member's focusing on kind of the second one, the civil injunctions, where there's a three-part test and the balance of probabilities. So we did kind of a look at how the public interest shows up when it comes to Aboriginal rights and title and Indigenous interests. And in some cases, like in the Wet'suwet'en case, it was considered under the public interest, but because there was a difference between the perspective from the hereditary chiefs and the elected council, the court determined in their independent way as they determined. But interesting, I think it was the Haida case in 2004, right, where that was an injunction-based case, where the court said, like, injunctions may offer only a partial, imperfect relief when it comes to this, and that whole area of law of accommodation and consultation and how it's developed in terms of taking into account Indigenous interest. I do think that there's a lot of, there's other cases that our team has pulled up where, you know, in some cases the public interest, the independent courts decided in favor of the public interest being the rights that First Nation was saying and enforcing. So it's a very kind of complicated area of law, but I do take the point about us always looking at things. And we have now Colleen Spear, who's right behind me, who is the Associate Deputy Minister of our Indigenous Justice Secretariat. And they are always speaking with First Nation leadership and the First Nations Justice Council to see like how we do, now that we've enacted the Declaration Act, how we align our laws and our procedures to reflect that. So,
Member.
Thank you, and thank you for the response. Arthur Manuel from the Swetmik territory. I should know his community, but anyway, Art Manuel noted called the use of these civil injunctions the legal billy club. Was how he framed it. There's been a study back in 2019 that looked at 100 of these civil injunctions and found that 76% of them filed against First Nations by corporations were granted, while First Nations were successful against corporations only 19% of the time. And of course, all I'm doing here is providing a couple of numbers. I recognize that this is not. None of what I'm offering is perfect, and it would be challenging. But I just do it for context because the experience is that the way that these Crown and colonial systems are established I experienced it personally in the intervention against the Kinder Morgan pipeline, a legal process set up by the federal government where it was pretty clear that the First Nations that were involved in that were deemed to be outside the public interest. And we were crawling and scratching and asking to be considered as part of the public interest in the decision that was being made. And it wasn't. So I'm conflating a bunch of things here, but I do want to make the point that there is some evidence that shows that where these decisions land is putting a kind of a corporate interest ahead of an inherent right. And what I think makes me so uncomfortable is how it's framed in question period and how it's framed in responses from, not from the Attorney General, but from the other ministers that are responding to this, whether it be the Minister of Public Safety or others, that when just a very plain assertion is made that this is the rule of law, that it's far blurrier than that. It's far more complex than that. Yes, they've sought and got a civil injunction, but there's a whole bunch of history that is not being recognized or being acknowledged in this, and there's a whole governance aspect of it, as the Attorney General pointed out, with respect to who these agreements are signed with, who has the legal right and authority to lead, who do the community members view as their leadership. All of that has been so significantly disrupted that the answer in here might be a correct answer. It might be one that we can feel comfortable with, but when you take it and bring it into the community, it doesn't make any sense. Or it feels like you're just continually pushing that rock up the hill. I'll just ask this. Sorry. I'll just ask this to this question. There was a time when these civil injunctions were granted, and then the company would then, or the people, the corporation or the person that received that benefit of that injunction would then have to go get an enforcement order. But now we're also starting to see the injunction and the enforcement order going out at the same time. So there doesn't even necessarily now need to be any disruption at any time. It's immediate, they're immediately put together, the injunction and the enforcement order. Can the Attorney General maybe comment on those changes and the impact that that has on the ground, and then of course with the use of the CERG, which has been created to basically deal with these issues, Trans Mountain, Fairy Creek, Wet'suwet'en. It's pretty clear what that policing unit has been designed to do, and that is to protect these civil injunctions that have been granted and the enforcement orders that come almost immediately with them.
Attorney General.
Okay, thank you. So generally speaking, I just did a real deep dive in this for you. So generally speaking, an injunction's enforceable on its own, right? You wouldn't need an enforcement order. There are instances where the private interest that has the civil injunction in their favor could seek an enforcement order. And one of the reasons that they may do this, and this is discretionary by the judge that hears it, is to provide certainty to both the police and the person that's accused of what type of conduct would, for example, result in a contempt of court, or like what are the bounds of that conduct. There have been instances where judges have granted enforcement orders, some where they haven't. In terms of the role of the Attorney General, it would, generally speaking, the discretionary decision to do anything under that would be if that private interest under the injunction reaches a level of public concern. So for some reason the conduct is reaching that level, and then the Attorney General might come into play in that position. So that's the kind of way it works. I do want to add also that we as a ministry are doing kind of very important work on Indigenous legal orders. And so the idea of that is to understand, and it's different with each scenario in each First Nation, understand how we can build up Indigenous legal orders for communities and kind of have the colonial system recede. And that's going to be different in every scenario, but it's really important work to think about how the transformation could happen.
Member.
Thank you. And I appreciate the challenges that having this conversation in this forum might cause, just in terms of separation of powers and responsibilities. Ultimately, the power and the responsibility does flow back to this institution here, and while we have to maintain the independence of the courts and the independence of the policing decisions that are being made, it flows from decisions that are made in this building. And so I guess part of the frustration that I've experienced when I've been trying to seek and find the accountability and the transparency in this is that the responses are always, well, it's their responsibility, or it's their responsibility. And so I guess what I've had a conversation with the Minister of Indigenous Relations about how this impacts Indigenous people in the province. I've had a very public interactions with the Minister of Public Safety, and that will continue. Budget estimates for him, for that minister, are next week, so I'm sure his staff are noting that these kind of questions will be coming. But also I wanted to raise this with the Attorney General, because I think that, very much a pivotal ministry in all of this as well, that we're taking care, that we're balancing and recognizing that, especially when language like the rule of law is being used to describe kind of a very narrow slice of that, and that there's this whole other aspect of it, especially with inherent Indigenous rights in their territories, and the mess that's been made of our governance structures over the years, and the work that we're trying to do to put it back together can cause a lot of damage in our communities. So I just wanted to, and I hope that the Attorney General can bring that to her colleagues, and just for those questions in the future, which I hope to not have to ask. Just leave it at that. The Yahe decision in Blueberry River, just switching gears here, and I don't have a lot of time left, but I do want to just ask what the Attorney General's perspective is. I come from the Husaitnich community, which is here in a very urbanized part of the province. I had a fairly long exchange with the Minister of Indigenous Relations about the impacts that the decision that was made by the BC Supreme Court, and then the decision that was made by the government to not appeal that decision, but to accept it and work with the Blueberry. And then we saw the result of that ongoing conversation that happened and negotiation that happened with the federal government just a couple of weeks ago, or maybe last Sunday the announcement was made. How does the cumulative impacts of the Treaty 8 rights that were, those rights have been around for decades now, and the Douglas Treaty rights, which were signed and almost identical in their language, reflect what's happening here in the Satanich territory, where we don't have loss to our right to hunt and fish or access to our hunting grounds and our fishing grounds because of oil and gas development. We have it because of virtually every other policy. We've got entirely, all of our hunting and fishing grounds are either fully controlled by the federal government for the fishing, and the hunting grounds have been entirely developed into real estate. So how does that, clearly the Yahé decision does not just, it's not only the Treaty 8 nations that are implicated in this, it is all nations in the province. When it comes to the urban communities that have treaties like the Douglas Treaty, how does the Attorney General see that this applies in this urbanized landscape? And what can the people, the Satanich people that I represent in the legislature, expect to see from this provincial government in that context?
Attorney General.
Thank you. Thanks for the good question. I think the Blueberry decision, and I practiced in this area before I was Attorney General, really signaled a shift in a government approach, because the decision of cumulative impacts not being appealed, but that instead the approach was to sit down and figure out to find a resolution. And of course, like that approach is, I think, with the Sanic people or the cumulative impacts that they may see through the treaty, is an important one. And I would expect that government or Murren would be interested in figuring out solutions if that's the case. I think it signaled also part of ongoing work we're doing about the directives that we issued to our lawyers, which sets out an approach that is different when it comes to this litigation, which is to seek resolution and only go to the court in instances where there are differences that can't be resolved through those discussions. And so we had multiple, at this point, kind of education sessions with our lawyers that work in this area to kind of talk through that and how that shows up. And I think it's important to listen to, especially with treaty rights and any implications on that, to seek a resolution like Blueberry that didn't involve litigation necessarily. And with that finding of cumulative impacts that was made by the Supreme Court of Canada, it set kind of a clear idea of, for the Blueberry First Nation, where the issues were with what was going on the land and their treaty rights. And through that agreement, I think, which is kind of what our approach has been as a government, and we're transitioning to, is government-to-government discussions on resolving it.
Member.
Excellent, thank you. And thankfully, those conversations are going on in the community. I just do recognize it to be one of the more significant decisions that have been made by a government with respect to Indigenous rights and legal decisions. We're so used to every decision that comes made at a province, then another 14, 15, 20 years is burned, taking it to the Supreme Court and putting it in place. So it was quite remarkable that that happened. Maybe just shifting gears one last time before I hand it over here to my colleagues. The provincial government committed to opening 10 Indigenous justice centres. I guess the question just is very general. Maybe the minister can provide an update as to where that project is in process, and where we're at today and the timeline. And I'll just say before I sit down, former Chief Art Manuel was from the Nisconlith people and whose mother came from Tanaha. So I just wanted to acknowledge that. I didn't want to suggest that it was just that Arthur Manuel from nowhere. So definitely Arthur Manuel from Nisconlith was who I was referring to. So thank you.
Minister.
Yeah, I'm very excited to report on the progress here. We, as a member may know, we're taking, the lead is really held with the First Nations Justice Centre, who's been staffing up and really ramping up the Indigenous Justice Centre. So the member may know we have 3 right now and 1 virtual, and the 5 locations for the next ones have been identified. And I'm told from the Justice Council they've done site visits to all of them. So they're actually right now looking at for the locations in the communities, and their approach is really actually quite wonderful because they're always designed with the local First Nations in mind and what the local concerns are, because it's going to be different in each part of the province when they're set up, and Indigenous led, right? So it's like you come with a legal issue, you're going to speak to an Indigenous person at that center, and kind of figuring out what the local like cultural support somebody might need if they're focused on it. And so the next sites, I think Kelowna, Surrey, Vancouver, and Nanaimo. I guess the site visits are underway there. I think Chilliwack is getting kind of worked on. I think it's probably close to being ready. I'm not sure if I'm supposed to say that. The sites are we're up and running with those ones. So we'll get to 10 and hopefully to 15 in the next few years.